Could I get a copy of this when you're done?
Yes,
whenever you're ready.
We actually record the presentation and we will send it out.
Great.
And it's also on Facebook Live.
Well, that means I better be better than I thought.
Good afternoon, everyone. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods under the direction of Division Manager Paul Green. On behalf of Mayors Sylvester Turner and Director Takasha Francis, we want to welcome you to the Month of Service. The Month of Service program is all about giving back free information to the Houston, Harris County, and Texas community. It's all about giving you back free information, and that's why we called it the Month of Service. We wanted to make sure that everyone had all the information they needed, that when you're ever going through a single stressor in your life, that you have everything in front of you that you can say, okay, this is step 1, 2, 3, 4. There's just one little bit, difference is that it's all virtually. And these virtual workshops are free. We're not asking any donations. We're not asking any money. We're just wanting to make sure that you all have all the information in front of you, that when you go through a stressor, and when we're talking about stressor, it could be everything in your life that can happen. It could be divorce. It could be childbearing. It could be hurricanes. It can be any type of disaster. It can be any type of daily living that you're going through. That's what we're all about. We want to make sure that everyone has whatever they need to make the correct, decisions. Guys, you know what? Usually you see one person other than me, and you usually see Miss Nia Murray with Neighborhood Recovery. Nia, we miss you, and we're hoping that you do well in Austin, which we know you got this. So we miss you, Nia, and we want to, just tell you that we are doing the presentation today, but you're the lead, and you're in our thoughts and prayers. Guys, the Month of Service virtual workshops are all virtually. We at first initially tried doing it monthly and quarterly and in person, but then when COVID came, we were all meeting as partners, and all of a sudden it seemed like our phones rang at the same time, and we all just stopped, looked at each other, and we said, wow, we can't have any more in-person virtual workshop. So within 1 hour, our partners, and our partners are Neighborhood Recovery, City of Houston Department of Neighborhoods, Harris County Appraisal District, Harris County Tax Office, Houston Volunteer Lawyers, Houston Bar Association, Lone Star Legal Aid, TSU, Earl Carl Institute, all 8 partners. Within 1 hour, we came up with this virtual program. And actually, guys, it's working because we can record. You'll get a recording of this virtual workshop. You'll be able to see it free on Facebook Live. We can also see it on YouTube, at Amos Houston. You can also, we are working on TikTok. I know I keep saying it, but we're just like, it's hard to get on TikTok, but we're gonna get in there and we're gonna get it started. But all these virtual workshops are free. And it's all about this amazing partnership that we've created, and that none of these partners ask for anything. Everything that they're doing is free of charge. They are donating all their time, and they're wanting to make sure that the Houston community, Harris County community, state of Texas community is educated. So today we have a wonderful presentation. It's under the Houston Bar Association sponsorship, and it's called the Landlord and Tenant Issues. And it's Mr. Mark Yablon, right or wrong?
That'll work. Yablon, like yabba dabba do on the Flintstones.
Yablon. I keep trying to say it in Spanish, and he keeps correcting me. I apologize. Okay. Thank you, Mark. So I am going to be quiet because you all know, the ones that come here all the time know I can talk. So Mark, thank you so much for taking time out of your busy schedule, and it's all on your hands. Thank you, Mark.
Oh, my pleasure. Thank you, Myra. So good afternoon, everybody. I guess it's probably hard for everyone to be able to respond to my questions. Is there I forgot to ask you, Myra, if there's a way that I can get feedback from the participants?
Yes, they can put all their questions on chat. And then what we'll do, we'll be monitoring the chat, and we'll also be monitoring Facebook Live. So if you have any questions on Facebook Live and on chat, please, we'll go ahead and Mark, you'll be able to look at the ones on chat.
All right, excellent. So is anybody here interested in commercial landlord tenant issues? If any, I'm assuming everybody's more interested in residential, but if anybody is interested in commercial, would you just respond in the chat? Or most of you don't have your video on, so if you could just put in the chat that yes, you're interested in commercial. And if I see nobody that's interested in commercial, we'll just focus on residential. All right, so it looks like we're going to focus on residential. Okay, my next question is anybody in the group a landlord? And if you are, if you could just in the chat say yes. And it's looking like nobody is a landlord, which I'm not surprised. Oh, there is somebody. P is a landlord. And then if anybody has ever been a landlord, would you say once upon a time or in the past? If you could just type that in the chat. Okay, so I'm going to focus my energies on the viewpoint of the majority of the audience, which is a tenant in someone else's property in a residential environment. However, if you have a question because you're thinking about becoming a landlord, or you might be renting office space from somebody sooner than later, certainly feel free to ask those questions. So let's begin with, has anybody been evicted? You could just type in yes in the chat if you've ever been evicted or they've ever attempted to evict you. So that looks like we got yes, when I was very young. Okay, anybody else? So that's probably good news. Is anybody facing eviction? If you are, just say in the near future. if you think you might be facing eviction. All right. And I'm gonna start my presentation in just a few seconds. If you have any questions for me, feel free to ask in the chat and I'll try to get to it as I can. All right, so sounds like most of you have been blessed to not to have faced an eviction. And hopefully after today, you'll be even less likely to face an eviction. So basically, if you're going to rent a home, you're going to sign a lease with a landlord. But some of you might have not signed a lease, but just have an agreement, what we call an oral agreement. Does anybody have an oral agreement for their renting of their property? Okay, so it looks like we don't need to talk about oral agreements. If I'm mistaken, just feel free to add something as we go along. All right, so has anybody signed a lease and hired an attorney before you sign the lease to review it? So I'm seeing Ms. Lopez is shaking her head no. And has anybody ever signed a lease? Excuse me, has anybody ever consulted with an attorney before signing the lease? Okay, so it looks like pretty much nobody has signed a lease after first consulting with an attorney. It may not be a bad idea for you to consult with an attorney to see if the lease you're looking at has some really crazy terms in it that would just be appalling if the landlord tried to exercise them. What I'm going to try to do today is guess a lot about what's important to you, but I'm going to sort of pretend like you are my client and you're coming to me with a lease. So a lease is just a written agreement that says, I'm the landlord, you're the tenant, you're going to rent this home, this apartment, this condo from me. Typically, it's going to be at least 6 months, and it could be more than a year, but usually it's about a year. And so that basically means you're going to pay rent for 12 months, even if you decide to move out in 2 months. There are very few exceptions for you to be able to break your lease or to move out early. Some of the exceptions that are in the law are habitability. I'm not even sure if I said that right. Basically, wherever you live must be habitable. If there's raw sewage running down your walls, you would have grounds to break your lease. If there are shootings going on all around you, you would have options to break your lease. If the electricity keeps getting turned off or gets turned off one time, not because you didn't pay the money for it, but because the landlord didn't do whatever the landlord's supposed to do, and the utility company came in and turned off the electricity or the gas or the water. Those would be grounds to break your lease. And when I say grounds, I'm not guaranteeing you that you're going to be able to break a lease without any repercussions. I'm letting you know that there are, if the judge agrees with you or a jury agrees with you, those would be grounds for breaking the lease. If anybody is a recent victim of family violence, that could be a reason to get out of your lease. So if your significant other did something, say slapped you around or beat you up or something, horrible like that, then if you wanted to get away from that person, you should consult with the district attorney for criminal charges, but you should also consult with an attorney to see about the best way to approach your landlord to get out of the lease. I don't have the law memorized, but if you wait a year and a half, it's probably going to be too late to say, I want to get out of my lease because my significant other beat me up a year and a half ago. Does that make sense? And of course, I really can't see hardly anybody, so I'm assuming it makes sense. We have a question here. Can you speak on reasonable accommodations and modifications for physical impairment, and who should pay for the modifications? Well, Bobby, that's a great question. And as lawyers too often say, it depends. And I know whenever I would consult with an attorney before I became one, I always hated that answer. But now that I'm an attorney, I realize there are very few things that are just truly black and white, yes and no. So reasonable accommodations would fall under the Americans with Disabilities Act. And it also, there may be some local laws in the Harris County or the city of Houston or whatever city any of you might be living in that would require some accommodations. So for example, some leases say no animals allowed. Just dry, simple, you cannot have any animals. But there's generally an exception if you have a seeing eye dog or you have a animal that is a comfort animal. And if you're in that situation, you should approach the landlord and let him or her know your situation and see if they would accommodate you. And if they say yes, then you should put that into the lease. If they say no, then you should decide, is this a place I really want to live? Because if this landlord is not willing to accommodate your needs, you might be much happier finding a different place to live. but not everybody has the luxury to find different places to live. So I understand that. At that point, you might want to consult with an attorney and ask them to review your lease and see your lease, what they've got in there for accommodations, as well as specifically what your accommodation is that you're wanting. And I cannot speak for the Houston Volunteer Lawyers Association, but there are various groups in Texas, Lone Star Legal Aid, probably Houston Volunteer Lawyers, and other organizations that might provide you some basic guidance at no cost. However, please check with each organization because I don't represent them, so I don't want to misspeak. Now, if let's say that you are now disabled and you're in a wheelchair and you can't get through the front door, then you should also approach the landlord and ask them, would they expand the front door? Would they add handrails to your bathtub if you're maybe a little bit older or you're unsteady and you need help? And if the landlord won't do that, then again, not to sound like a broken record, but I would check with with an attorney and ask them to look at your lease and what you're trying to accomplish. You might also check with planning and planning and development office for the city that you live in and see if they have sort of an ombudsman, that is a person that you can talk to that can try to act as a go-between you and your landlord to get things fixed. But generally, if the Americans with Disabilities Act applies to your apartment complex, then the landlord would be the person responsible for paying for and accomplishing the modifications. If you're renting a room in somebody's garage apartment, they probably have an exemption to where you'd have to find another place to live if they weren't willing to make those changes. So if you want to ask a follow-up question, please feel free to do so, Bobby, or anybody else for that matter. All right, so I've referenced the lease. The lease is so important in protecting your rights, because if the lease says that the landlord promises you quiet enjoyment, as an example, quiet enjoyment means you're not going to be harassed by your landlord. So I don't know if anyone has ever come home from work or play and found the landlord in their apartment. If you have, that could be quite startling, especially if you've never experienced that before. Well, if the lease says that the landlord can come into your apartment anytime he wants to do anything that he wants, well, then you don't really have a whole lot of protection. But if the lease, which is more likely to say the landlord must give you advance notice before coming into your apartment, unless it's an emergency, if it has some provision like that, but yet the landlord comes into your apartment, then you might have grounds to complain. And again, if you want to stay in that apartment or that rental house, maybe there's no need to exercise all of your rights that aren't bothering you. But at the same time, if it turns out that you think property management is taking advantage of your situation, you might want to start documenting it. And when I mean documenting it, meaning documenting what have they done wrong, when did they do it, who was the person that did it, how did it harm you or bother you or hurt you, how did you communicate your request for that action or that lack of that action to stop or for action to start, depending on what the situation is. And I'd keep a record of that, because frankly, if the landlord screws up minorly once or twice in a 12-month time period, I don't think you want to worry about, exercising your rights, so to speak. But if that landlord continues to harass you or continues to bother you, then then you may want to look at moving out early and want to go to the landlord and give them your reasons and say, you are violating, you're in breach of contract, you're violating this lease, and I'm moving out on this date. And you can do that. The risk, though, in doing that is the landlord could say, you breached the lease, and then go to small claims court and file a complaint against you. And then you'd have to countersue the landlord and say, well, I moved out because they breached my lease here, here, and here. But again, before you get to that point, I would consult with an attorney to make sure that you're on good ground for taking that chance and to understand what your repercussions might be. So let's talk about rent and security deposits. Your rent could be $500 a month if you're renting a one room in somebody's house. Maybe it could be $2,000 a month if you're renting a 3-bedroom, 2-bedroom, 3-bedroom apartment somewhere. So you're going to pay your, as most of you I'm sure have experienced, you're going to pay your rent each month. And they're going to want it due on the first of the month. Most leases will give you 2 or 3 days, maybe even 4, to be late without any repercussion. But it's very important. It's very important that you pay your rent timely. And I would encourage you, if you have the money, pay it early to show your landlord that you're a great tenant, because one day you might not have the money and you might be late several days. And if you've been early the past 6 months or 3 years, then your landlord would have to be pretty much a moron not to give you grace and say, okay, I'll give you till the 10th without you having to pay a penalty. Does that make sense? All right, great. Now, security deposit. So again, I don't know anybody's financial situation, but some landlords might do a credit check and determine what they believe to be your credit worthiness. And they might charge a higher security deposit for someone that is at what they perceive to be at a higher risk to not pay rent on time. On the same basis, some places may say, I'm not going to rent you this house or this apartment because your credit history is bad. And what I know some people have done successfully is when they had the ability, they've said, okay, the typical deposit might be a month. They will pay 2 months rent up front as a deposit to give that landlord more assurances that they're going to pay on time. Unfortunately, not everybody has the financial means to do that. And if you cannot come up with the security deposit to be able to get the space, then I'm not aware of anything that you can do unless you feel that you're being discriminated because of a protected class or your age or your familial status. There might be some options you would have if you feel it's really not about the money, but about you personally. But let's assume that this is about that you just don't have a good credit history and they're wanting to not rent to you and you can't come up with the right security deposit. Then save yourself a lot of grief and go ask another place and look around, because there's going to be landlords who will either be in need of tenants and they're going to be willing to accept somebody that's currently in a temporary, not the best situation, or that they may just be compassionate and willing to help somebody out and give them a hand up. Let's say that you rented the place, you've paid your deposit, you've paid your rent on time, your lease is coming up for renewal, and you don't want to renew for whatever reason. You have the right to give them, and it's going to be in your lease. It could be 30 days notice. It could be 60 days notice. It might even be 90 days notice. It's very important that you look at your lease and see, how much notice do you need to give in advance to terminate your lease? Because some leases might say you automatically renew for another year. And if you weren't planning to do that, that would be really problematic. Some leases might say that you automatically renew month to month, but you got to give 90 days notice, which means it's no longer month to month, because you're thinking my lease is up December 31st. Today is Thanksgiving. I'm going to go ahead and give you the notice, and you're ready to move out. And the landlord on January the 2nd says, not so fast, even though you've already moved out. And yes, that happened to me as a tenant, effectively, a little bit different facts. And he said, all right, you didn't give me the 90 days notice or 60 days notice, so I'm keeping your security deposit. Well, that really is not does not feel good. I can assure you that. So you don't want to be in that situation. Okay. Let's say, though, that you didn't read the lease properly, or you read it properly, but for whatever reason, you did read it properly, and now you're terminating your lease according to all the lease terms. That landlord is supposed to, as part of your termination, you need to give them a good mailing address and a request for your security deposit. And if I were you, I would mail it to them, certified mail, return, receipt requested through the U.S. Post Office. That's certified mail, return, receipt requested. It's going to cost you about $8 to $10. It's where it goes, it's mailed out, but the landlord has to sign for it at the post office, and then you're given a green card mailed back to you a week or so later as your proof that you did give notice to the landlord on a particular date. So you've done that. You've asked for your money back. You've given the landlord, and this is all in the law, you've given the landlord your forwarding mailing address, because if there's mail that comes to you, if you haven't already notified the post office, you want the landlord to know how to send stuff to you, but also it's required of you to do that for the landlord to refund your security deposit in a timely way. And I don't have it memorized, but I believe the landlord has roughly 30 days to refund your money or to give you an accounting of the money that the landlord kept and why. So in English, what I mean by that is either the landlord refunds your entire security deposit because you met all the terms of terminating the lease, or the landlord says, you had a dog and the dog soiled the carpet and it cost me $700 for new carpet, or cost me $700 to clean the carpet. And I'm just using crazy numbers on the cleaning part to make a point. And he sends you back $300 of your $1,000 deposit. And of course, you're not going to be pleased. You're going to say it did not cost $700 to clean the carpet. And you're going to want an itemized bill, and he's going to have to send it to you. And if the bill turned out to only be $250, well, then he better refund you another, let's say the bill turned out to be $300. So 700 minus 300 is 400. He better refund you another $400 because he exaggerated in his original accounting. If he doesn't, then you have grounds to file a suit in small claims court, which I would again encourage you to have an attorney do that for you. But you have the grounds to file a suit that they breached your contract. And if he unlawfully, or she unlawfully, takes your security deposit, you might be able to get damages, meaning he has to pay you additional money as the statute would require. So for example, if you ask for your money back and he doesn't give you your money back and he doesn't give you an accounting, he just simply says, no, I'm not giving you your money back, or go jump in the lake, or he doesn't even respond within the time limits that the law says, not only would you get your money back, but you might get 1 to 3 times the money in dispute back. So if you had $1,000 security deposit, there's a chance you might get back 2 or 3,000 from him. Plus, he might have to pay your attorney fees. So my main takeaway in this is before you sign a lease, as I said earlier, you should consider having an attorney look at it. But I really encourage you, before you terminate a lease and move out, have an attorney look at your lease and see if there's some gotchas that you need to be careful. And then once you move out, if you hadn't talked to an attorney and you ask for your money back and you don't get it, then definitely you should consult an attorney. I give typically a half-hour free consultation. I know a lot of attorneys do that. Some do not. So you might have to call, half a dozen law firms before you can find an attorney that would be willing to at least talk to you. So if anybody thinks that I'm going too slow, please type in the chat, speed it up. If anybody thinks that I'm going too fast, please put in the chat, slow down, so that I kind of have an idea. All right, well, thank you, Myra. I appreciate that. I'll have to send you my tip later on that. Okay, so let's look at some other terms. When you're the resident, typically you're not going to have to pay property taxes when you're a residential tenant. Typically, you're not paying directly for property taxes. Some landlords will even cover the insurance on the property. Some will cover utilities even. But let's say that they cover everything. They really didn't cover, I guarantee you they did not cover insurance for your possessions. They may have covered insurance for the building, for liability against them, but I doubt very seriously they covered liability for your computer if it got stolen, or if there was an electrical shortage and it shorted out, or if there's a roof leak and it washes out your favorite photos or paintings, or your bed gets soaked and you have to buy a new bed. So you probably should talk to your auto insurance agent and make sure that you're covered properly for insurance. Sometimes it's known as renter's insurance. And of course, your insurance agent doesn't practice law, but they might be able to look at your lease and look at the insurance terms and say, yeah, they're covering you for insurance, but most likely they're not. Use of premises. Well, most leases, I'm pretty sure, are going to say you cannot have more than so many people living with you on any given day or at any given time. And part of that is, and I could be wrong about Houston, but I'm sure Houston, like many cities, has a limit that says no more than so many people may sleep in a bedroom unless they're related. I think some cities even say, even if you're brother and sister, or sister and sister, or brother and brother, you can't have more than so many people in a bedroom, which by definition means, depending on how many bedrooms, you can only have so many people in the apartment or the house. Some leases may even say you cannot have a relative. Like, for example, I had a lease one time that I was a tenant, and it said my own children, adult children, could not visit more than 5 or 10 days a month. And then I had to notify the landlord that they were going to come visit. And I certainly don't want to encourage you to break the rules, but boy, those are some pretty onerous rules to say you're supposed to notify when your adult children are coming to visit, or your brother, or your sister, or your friend or buddy. But what you really want to be careful about is if your friend, buddy, or extra people that are not on the lease are there 10 days at a time, or 5 days, or 6 months, because then you're opening yourself up to a complaint or worse from your landlord or from your neighbors. I suspect if there's lots of parking, probably no one, and you're not loud, probably nobody's going to complain. about that. But you ought to be aware of it, because it'd be horrible for you if you invited a bunch of friends or family over for spring break or Christmas break, and all of a sudden your landlord's saying, they got to go. You didn't give us advance notice, or there's more than, more people are staying here overnight than they're allowed, or your neighbors are calling the police on you because you're too loud or too many people. My opinion is, if you're going to break the rules, I'm not telling you to do that, but if you are, at least know what rules you're going to break, why, and how you're going to respond. But even worse, it would be to break the rules and not know about it, and then you're stuck, and it's maybe too late to remedy the problem. All right, so some of you might be of the opinion that the walls are too boring, they're just painted white, cream, or they're too exciting, they're painted pink or red or purple, and you want to paint it a different color. And for any of you that have been tenants for very long, you probably know that that's a not acceptable behavior. But even though I say that, one of my clients is a commercial landlord, and he actually had a tenant that painted his office building Barney purple, big old polka dot Barney purple all over the interior of the office building, purple on the outside of the commercial building. And then these adults moved out and didn't think they should have to repaint the building. They painted some of the walls pitch black, like you might have if you had a black light and you were an 18-year-old kid. And so nothing astonishes me anymore. You don't want to do that. And if you do, put it in writing and ask your landlord for permission to do that. Don't rely on your landlord saying, yeah, that's no big deal, because chances are you're not really talking to the landlord owner, you're talking to the landlord manager or the landlord administrative assistant, who may not be there the day you move out. They have gotten mad at you and just decides to lie, or could be forgetful, or y'all both just have a disagreement about what the reality was. So if you want to make any changes to your premises, to your property, put it, maybe talk to the landlord's representative first. If it looks like it's realistic, it's going to happen, then put it in writing and confirm what you want to do, and ask them to reply back that, yes, this is acceptable. But even if it's acceptable for you to paint or to put up wallpaper or take down wallpaper, change carpet, put up window shades, or any number of things that might be allowed, you should expect that the landlord is going to want you to put it back the way you found it before you move out, or the landlord may charge you money for it. To completely contradict myself, you also should expect that the landlord says, that is my property now, you cannot take it and you cannot change it when you move out. So again, you go back to the lease, and it literally should tell you, if you make changes, if the landlord approves it, it becomes the landlord's property. Or if you want to make changes, the landlord approves it, but you must return it to its current condition the way you found it, more or less. Just know up front. All right. Say you've got a crazy relative or friend over who gets mad and punches a hole in the wall, or brings their dog over who does things. In any event, that would be damage or destruction to the property, and you would, well, really your friend or your invitee would need to fix it or repair it, but they might go, I'm not going to do that. Well, that's fine, but you're still going to be stuck with it. Your landlord isn't the one that invited the person over, so just be prepared for that. You might even want to start putting away $50 or $100 a month, if you can, into a savings account just to handle the unknown crisis when it's time to move out. You also might want to put away that money so that when you move to the next place, you'll have money to pay for renting a vehicle, or hiring somebody, or putting down your next security deposit while you wait to get your old security deposit. some leases will allow you to assign or sublet. And without boring you with too much detail, basically that just means you've been here for 3 months and you or your significant other just got transferred to San Antonio, and now you want to break your lease. And your landlord says that'll be $5,000. And of course, that for most people would be crazy money. So you might be able to try to find a person to take over your lease. If you do, I would strongly encourage you to get written permission from your landlord, because you would hate to have somebody move in, you move out, you're in San Antonio. 3 weeks later, you get a call that the landlord is evicting those people because they didn't have authorization to be there. You also want to be careful that even if the landlord allows the person to come into the property and they're paying rent, but then they damage the property, well, you're still on the hook, even though they've signed an agreement to take over your rent. The landlord needs to completely let you out of the lease for you to be completely off the hook. And if anybody wants me to elaborate on that, please put something in the chat. So when you break the lease, breach the lease, violate the lease, default on your lease, those are all basically the same thing. You don't do what you agreed to do, then the landlord can sue you for damages, for money to fix what you didn't do, to replace what you did. But the same is true that if the landlord violates, breaches, breaks, doesn't do what they promised to do, well, you have the right to sue them for damages. You just want to be careful that you don't get into a lawsuit that you don't think you have a good chance, because unfortunately, attorneys aren't cheap. And even though most leases will say that the winner gets their attorney fees paid, the court might not order the landlord to pay your attorney fees if you were to win, or they might order the landlord to pay just some of it. And alternatively, if you're the person being sued, or you do the suing but you lose the lawsuit, you might be ordered to pay the landlord their attorney fees. So just be aware of that. Couple other miscellaneous things to think about would be let's say that you're renting, but the landlord doesn't pay her bills, that the landlord most likely has borrowed money against the property from the local bank, and the landlord stops paying. Has anybody been in a situation where you paid your rent, but you got an eviction notice because who you were renting from didn't pay their mortgage? That happened to me, where I was actually, I was buying a house. The current owner let me move in early, and before we could close on the property, the bank foreclosed on the person selling me her house. So I ultimately got evicted, not because of anything I did, but it's because of what the owner of the property did not do. She did not pay her mortgage. And I was able to fight it and give myself, this was before I became a lawyer, but I was able to fight it, and I was able to stay there for 2 or 3 months to give me plenty of time to find a new place to stay. So if you are ever in that situation of being evicted because getting an eviction notice, you can go down to the JP court on the date that it tells you to, and you can object. And you can say to the judge, I'm the tenant. I'm not in control of what the landlord does. This, assuming this is true, this is the first I've heard of it. And having to move out in 3 days or 30 days is just not enough time, and it's not fair to me. And you can ask the judge for a 2 or 3 month extension. And the judge might turn you down or might agree, or the landlord's mortgage company might decide before you ever get to court. You could contact them, and they might say, okay, we're not going to do anything for 3 months anyway. Sure, we'll give you an extension. If you don't ask, you won't get. That's the message here that I'm trying to portray to you. And things you would never expect might be thrust upon you, such as when the landlord doesn't pay the mortgage, you're now stuck, and the new landlord says, I'm foreclosing. And when they foreclose, that generally means the lease you had signed with the landlord is no good. It's torn up. The landlord could file bankruptcy and say, I don't want to own this property anymore, or I want to own the property, but these leases, my tenants don't pay enough rent, and I want to get out of my leases with all my tenants. And a bankruptcy judge could actually allow that to happen. So I hope I'm not scaring anybody, but those are some things that can happen that you would not expect. Okay, another big issue is environmental issues. This is probably more likely if you're renting a house rather than an apartment. But I have a friend, and she rented a brand new apartment. And she started all of a sudden suffering depression, skin problems, breathing difficulties. I mean, she literally thought that she was just completely falling apart. She lost her job, and she was making very good money by anybody's standards. And it was a brand new place. She started investigating, and turns out some of her neighbors had some medical problems that sprung up after they moved in. Whether it was related or not, she said a young man below her died, and I think someone else had died. But you know, if you're living in a big apartment complex, that may or not be shocking. However, a lot of weird stuff. She moved out, and her health was good, started getting better. It took her a while, but it started getting better. So be aware that when you move in, if all of a sudden you or somebody that's living with you, your health starts changing very quickly, I wouldn't wait. You might want to talk to the landlord about it. You might want to find out what chemicals are being used to exterminate, to clean the property, or what's being stored. She said that she saw barrels of chemicals stored in the parking garage, which was near where her apartment unit was. And she believes that she was poisoned. But by the time she moved out, by the time she was able to really understand her situation, it was probably too late to go after the apartment. So my encouragement to you is, if something happens that you notice is different, don't just assume it's just the weather, you know, a week later, if it's still happening. Talk with the landlord, talk with an attorney, talk with your doctor, and investigate. Because if you are being hurt like that, that could be a personal injury claim, and a personal injury attorney might be able to help you get the medical care you need, as well as make the apartment complex or the chemical manufacturer or somebody pay for your damages. In spite of me saying that, that's pretty rare that could happen. But if your situation is that bad, you should at least know what your options are. Trying to think if there's anything else that just stands out in my mind. Oh, let me circle back to when you move into an apartment. I would make sure that you take a photograph of the ceilings, the walls, the windows, doors, and the carpet. So that of every room and hallway. So really that means taking 2 or 3 pictures probably of each bedroom. And I'd go from room to room to room. And then I would save the pictures, make a copy of the pictures, and then label them, what room it was taken in, anything you noticed, the date and the time you took it. And I would do that before you move into the apartment or the home. I would also take, if it's a house, I'd take a picture of the garage. I'd take a picture of the outside, each side of the house. If you could, I'd take a picture of the roof, of different angles, because what you want to do is document the environment you're moving into. Because a year from now, or whenever you move out, particularly if you're not happy and the landlord's unhappy, people's memory may not just be so good. And then before you move out, right before you move out, I would take the same photos to show that nothing changed. And then I would do a walkthrough. I think most landlords would require you to do a walkthrough at the beginning of your lease. And you have a questionnaire to fill out and say everything looks great or there's a problem. And then when you move out, there's probably a walkthrough and you do similar. And then the landlord compares the two walkthroughs to make sure nothing's changed. So you should do that yourself before you do the formal one, so you have a record. And then when you do it with the landlord, you don't need to take pictures because you've already got it, unless you just want to. But I think that would be a good tip. Or use a video camera and just videotape your walkthrough. Okay, let's see. Bobby, you have a question. Is there a general rule on how recent a closed bankruptcy on one's credit report can be used to deny approval of a new rental? Well, that's a good question. What I've always heard, and I do bankruptcy, but I don't have that specific answer memorized in my head, is that once you've been discharged in bankruptcy, you actually are a good credit risk because you can't file for bankruptcy for so many years into the future. So if you do have a landlord that is giving you, prospective landlord giving you grief, you might remind them of that fact that it's your understanding, you could say, that I filed I was properly dismissed from bankruptcy 6 weeks ago, and I can't file, I've been told, for at least several more years, so I'm a good risk. And if that doesn't work, then you could also offer to pay a higher deposit. And if you're not able to do that and that doesn't work, then you might ask do a free consultation with an attorney and say, hey, do you happen to know? And that attorney might know or might not know. And then you can go from there, whether you want to pay for the attorney to look up the law and give you that answer. But I don't believe there's any law that specifically says if you're out of bankruptcy, a creditor must give you credit. I can't imagine there would be a law on that. Okay, as a landlord, this is from Pete. As a landlord, how do we ensure that we find the best possible tenants while avoiding accusations of discrimination? Well, Pete, that's $1 million question. So I don't have it memorized, but the Department of Housing and Urban Development should have on their website, or at least they did when I looked several years ago, what are the discriminatory laws that apply. So for example, you can't run an ad that says, I'm looking for a blonde white woman between the ages of 25 and 40 to rent my back bedroom. You can't do anything crazy like that, or to rent my apartment. But there could be subtle ways that could get you in trouble. I'm looking for a mature tenant to rent my place. Could that be interpreted in a way that could be discriminatory against somebody? I don't know. But if you look up the code or the rules, they'll lay them out. Now, HUD, the Housing and Urban Development, they're going to have stricter rules, I'm sure, for Section 8 housing and any other government subsidized housing. I believe that there may be an exception to the rules if you're renting from an individual that owns 4 or less units, say a garage, a 4-car garage apartment with 4 units. They may not, I believe they're exempted from some of these laws. But Pete, the kind of question you have, you really should contact an attorney to better advise you and give you a checklist of things to do, or a checklist of things not to do that you could feel comfortable in following. I encourage my business clients to have an attorney on retainer. It's so much cheaper to ask questions before they pop up than to ask questions after a problem arises. Okay, iPad, you have a question. Is there a statute of limitations on filing a suit, whether you are a landlord or a tenant? Yes. Generally, there's a 4-year statute of limitations on a breach of contract in the state of Texas. So your landlord breaches the lease, or the tenant breaches the lease and does something that no doubt damaged the property or damaged the tenant, and you wait 3 months to file the lawsuit, you're fine. You wait a year, you're probably fine. You wait 2.5 years, the court cannot kick you out over the statute of limitations because we have 4 years. But there's another term called laches, L-A-C-H-E-S. That basically means my affirmative defense. The reason I should not be found liable for the damages to your property, even though I did it. Yes, I painted the walls purple and pink, and I did it, but it was 2.5 years ago, and you waited until now to sue me? Well, a good attorney would file an affirmative defense of laches, which means the landlord sat on her hands for 2.5 years. The evidence that would be necessary to prove what had happened is long gone. You moved out 2.5 years ago. There's a good chance 3 more people have lived in that space, and it's too late. You missed your time. Does that make sense? Whereas statute of limitations says the landlord waited 4 years and 1 day. All you have to do is say, it was accused of breaching the lease on this date in 4 years, and 2 days later, the landlord sued me for that breach. She missed her deadline, end of story, and the court is supposed to kick the case out, and you don't have to do anything. However, it's easier said than done because there could be a nuance you didn't think about, and you might still be having to defend yourself. Or if you're the plaintiff, you might still have an opportunity to go after that person. iPad. Okay. So is there a statute? I just read this. Is there a statute of limitations on filing a suit? And then iPad, you said yes. And I'm sorry, I just saw the yes. What was the question that you're answering? I'll wait just a few seconds. Okay, does anybody else have any questions that I can try to answer on landlord tenant issues? All right. Oh, you agree with my answer. Well, thank you, iPad. I appreciate that. And I'm going to share my screen for a second. And I'm going to suggest that if you're trying to find an attorney, one place you can go is called avvo, avvo.com. And so instead of having my ugly mug up here, we'll just go avvo.com. And you can look for lawyers. You can say, I want to find a real estate attorney in 77019 area code. Don't know what will pop up, but we'll find out. Okay, so you can see that they have different attorneys that pop up. They've got, for example, this person has a 5-star rating from clients, and he has a avvo rating of 10, which is avvo saying is the best that they can offer. But a lot of attorneys have a range of ratings. Here's some guy with a 6.5. a lady with a 7.5. Or you could say, I want to, that Yablon character, he sounded interesting. And I'm just going to type in Yablon, and he's somewhere in Texas. Okay. So the two Yablons that showed up, these other people are ads. The two Yablons that popped up are me and another guy who's in Dallas. I happen to know is in Dallas. You just click on the name and you can see where it gives my ratings, and then it talks about practice areas. You can ask questions to everybody on AVO that wants to answer them, or you can ask the attorney specific questions, and you can see that through the past year or two, I've answered 5 pages worth of questions, which might have something of interest. Anyway, I hope that helps. Again, my name is Mark Yablon, and I have enjoyed talking with everybody. And if there are not any other questions, then I'm done. But let me see. Oh, it looks like there's one in the chat. Okay. Thought you were going to get out a little early, but let's see. Luz Lopez, I hope I said that right. Thank you. You're welcome, Luz. Sheila says, since the pandemic, pardon me?
I said, thank you.
Oh, you're welcome. Since the pandemic, gosh, I can't even talk. Since the pandemic, some apartment complexes are charging more in utilities such as water and sewer. I was paying a total of $50 to $55 for the water, sewer, gas, pest, and garbage. Now I'm paying at least $70 for water and sewer and additional charges for gas, garbage for a total of $120, I presume a month. This was on the news from other tenants at several apartment complexes. They are price gouging the tenants. I have a family member that pays $45 for water and sewer for a 3-bedroom house and a 1.5-bedroom bath. So Sheila, thank you for the comment. I think $45 a month for a 3-bedroom house with a 1.5 bath does not sound very expensive to me. I've had a little bit bigger house and I was paying well over $100 a month at various times. But if you think that there is some price gouging going on because in the apartment you were in, you were paying $50 a month and now you're paying $120 a month only since the pandemic, you might want to go to the Attorney General's website. And let's see, I'm just going to put price gouging Texas OAG or Office of Attorney General. And then there's the Consumer Protection Division of the OAG, of the Office of Attorney General. And let's see. And here we go. So disaster and emergency scams, that could be it. And if you're a student, if you're a senior or elderly, you might have a second bite at the apple. And so you might want to consider contacting the OAG about that. So hopefully I showed you how relatively easy it is to go to the Attorney General's office and type in a code word like consumer complaint or price gouging, and it might get you quicker to where you want to be. Does anybody else have any questions or follow-up?
There's a lot of the nonprofit organizations that a lot of the community really have been using, which we found out that Lone Star Legal Aid, as well as Houston Volunteer Lawyers, TSU Earl Carl Institute, they have attorneys there that you have to conduct a complete intake, but that they will assist you if you qualify for their assistance. So a lot of
Right.
times, a lot of people feel like, you know, I do not qualify, or I can't afford to find, you know, hire an attorney. Well, there are different organizations that can assist you. So please don't stop and think just because I can't afford it, that you can't get an attorney. Yes, you can. There's,
Right.
you know, wonderful organizations, and that's what the month of service is all about. We also want to let you know you're not alone. And I love that information on Evo. That's great information. We know that in this world, life kind of turns us around at times.
Sure.
And so if you're in a position that, you know, you need assistance, but you know, you're like, look, I have to pay for my rent, I have to pay for my water, electricity, and my other bills, and I definitely cannot afford an attorney. But you feel like your landlord is not treating you fair, or they're evicting you without any type of assistance or any reason, then you can call Lone Star Legal Aid. You can call Houston Volunteer Lawyers or TSU Earl Carl Institute, or you can call NRCDC, as well as myself. My name, as many of you know, is Myra Hippolyte, and I will put my contact information. My name is, it's 832-394-0701. We cannot assist you, but we can kind of lead and guide you to different organizations that can assist you, as well as neighborhood recovery. And Diane, could you give out neighborhood recoveries information?
Sure, I can put it in the chat if it's okay.
Thank you so much. Are there,
You're
these
welcome.
have been really some great questions. Diane, what was the phone number and contact information? I apologize, for neighborhood recovery.
713-520-5232.
Thank you, Diane. So make sure if you have any questions and you need some assistance, don't hesitate to call Neighborhood Recovery, or you can call the City of Houston Department of Neighborhoods and ask for Myra Hippolyte. And I will put it in chat now. And know, guys, that you're not alone. You know, a lot of times you think, well, look, I'm just going to leave it alone, and I'm not going to get any assistance, you know, because nobody's there to help me. And I loved what Mr. Mark said is, look, these are the processes. This is what can happen. This what, you know, this is what they shouldn't do. The landlord can and can't do. But at the same time, you know, and he also offered, you know, hey, this is a way for you to find good attorneys. That's awesome information, you know, because you yourself say, well, I can afford an attorney. So let me go ahead and go to AVA. But in the meantime, you say, well, look, I just lost my job. You're trying to evict me. Hey, let me call TSU or Call Institute. Let me contact Lone Star Legal Aid. Let me contact Houston Volunteer Lawyers. There's somebody out there that can help us. Or you know what? Call nrcdc.org or the City of Houston Department of Neighborhoods, and we're here to assist you one way or the other. There's sometimes someone out there to help you. But
Can I make, when you're done, I'd like to make two other real quick points.
yes, I'm done.
Well, no, go ahead. I don't mean to cut you off.
Oh, no. I just want to let everyone know that you're here. You have a team of partners that are here to help you through whatever. One of the things, Mark, that I wanted to know is one question. So if you pay your rent on time every month,
right?
Let's just say you're paying your rent on time, and then all of a sudden you lose your job and can't pay your note. You call your landlord, and he says, well, no, you're gonna have to pay your note, and by God's grace you can't afford it. So then you say, well, I got to move out. So you move out with your parents, okay, because you know you couldn't afford it. You got laid off. Then all of a sudden you get back on your feet and you're looking to buy a house within that 7-year period. all of a sudden you realize that that landlord that you did let know that you had lost your job had put down that you had moved out and not paid your rent. Is there a process that you can prevent something like that happening beforehand? Like if you lose your job, there's a process that you should do, and then they wouldn't be able to put that information in your credit report.
I'm not aware, pardon me, I'm not aware of a law like that. But what I used to be a commercial landlord before I had a midlife crisis, and instead of buying a Porsche, I went to law school. But in my old life, if I had a tenant that had paid me on time and, for months or years, and then came to me with a personal crisis, and I believed that they were genuine and sincere, then I would find a way to work with them for a period of time. But in fairness to the landlord is paying mortgage most likely on that property based on the rent that they're receiving. And if the rent goes away, then the landlord's going to get, unless they're really successful, and there's a lot that are just barely making it cash flow wise, they may not be able to keep it, and they could risk for being foreclosed upon.
And that is a wonderful take. I love that, because I think most of our community don't realize that most landlords have mortgages on their apartments.
Most either have mortgages or they have investors. I'm less concerned about the ones with investors, because then it's just a matter of choices. Not totally, but more so. But when you've got mortgages on your properties, then you're almost like the hamster, and on that wheel, just racing. But that being said, if the landlord can afford to do it, and you've been a good tenant, the landlord would be an idiot to not help you for at least a short period of time. So let's say that you're wanting to, you realize that, your job went to Mexico, to China, and you're done until you get retrained. So you're not going to be, you're needing out of the lease. It's that bad. Well, I would go to the landlord and I would explain the situation, and I would ask, is there a way that if I move out ASAP, but I've paid rent for another 3 weeks, but I'm going to move out today. So you still have, or tomorrow or next week, even though I've paid beyond that, I'm not going to ask for a refund because I'm not going to get it, obviously. But if you can find someone between now and then you might make a little extra change. But I want a written agreement from you that you're going to release me from the lien, from the note, with no repercussions, and that you won't report me, and that if somebody ever asks about me, you will say I was a credit-worthy tenant. You can negotiate whatever the heck you think is realistic, and they might agree. But get it in writing. Don't rely on, no matter how nice and sweet she is or he is, it's not that person is going to lie to you later. That person may not be around later, or may not even be the person to respond. So you want something in writing, signed, that you can present to challenge something that shows up later. I will say that as a landlord, I never reported anybody that skipped their lease or didn't pay. Maybe I wanted to, but I just thought, you know what? I don't feel like I was a small-time landlord, and I suspect many of y'all deal with small-time landlords. Many of them don't even want to deal with it. So I wouldn't be overly worried. I don't know if that helps or not.
Yes, it does. And there was one person that had called me, and they said, hey, I stopped paying my rent because I've asked my landlord to fix my air conditioning over and over. And I finally got tired, so I stopped paying my rent, and now he's evicting me. Is there I know the answer to this, but I want to hear it from you.
Uh-oh.
No, because you'll tell me. I already know. But
no, that's okay. I don't mind. If I'm wrong, I'm wrong. I don't care. I care about being wrong and right, but I'm not. Unlike some people, my ego is not going to be harmed. If I don't know the answer, then now I know it once you correct it. But if the landlord has made your place uninhabitable because they aren't running the air conditioning, it is incumbent upon you all, the tenant, to say, I am moving out of the lease. I am terminating this lease because you have made it uninhabitable. You've made it impossible to live in, whatever, gets the point across. And effective today, I'm terminating the lease and I'm moving out. Just make sure that when you send that letter that you really are moving out, because you don't want to say I'm moving out and the next day the landlord shows up with a paint crew and there's all your stuff still in the apartment, because you just created a problem. Or don't do it as a threat, in my opinion. Well, I will move out. I will terminate in 2 days if you don't get this fixed. That's fine, but be prepared to move out in 2 days and say, I have moved out. Here's your notice. I've terminated the lease. I want my security deposit back within 30 days. Please send it to Myra Hippolyte at blank, blank, blank address. And that's way better than just moving out and hoping for the best. Or worse, like what Myra explained, moving out or not paying your rent, staying there but not paying, and then being evicted. Because at that point, the judge is not going to believe you that you didn't pay your rent because you didn't think the place was livable. But you move out and you run the risk of a lawsuit, you've now convinced the judge that at least you thought you had grounds to move out because it's not livable, right? Now, you might be wrong and you might still be in trouble, but guess what? At least you set the stage rather than, oh, wait, but forget all that. You've already done that. Now, the other thing that I was going to say, and I have now forgotten, so it must not have been terribly important. On avo.com, which I put in the chat, you can ask your question. So if I were you, anytime a question comes up, just anonymously or with your name, I don't care, doesn't matter. Go on there and ask a question for all of the attorneys in all of America to possibly see, or ask point blank to specific attorneys or both, or call them. So it's another door. Oh, I remember the other door that you can contact is, I know that South Texas College of Law has a variety of clinics. I think they've got a tax clinic. I'm sure they've got a criminal clinic. And I know they've got several more. I just don't remember what, maybe family law. I'm really not sure. But if you go on their website, South Texas College of Law website, and you type in clinics, something to that effect, or you call them, you should be able to find out what they have. And they sometimes, the professors who are attorneys and their students can help you. I think you mentioned TSU had something like that.
Mm-hmm.
I honestly don't know if U of H does, but the point is there are so many resources that you would never believe that are out there. You just got to try, like Myra was saying, don't stop with one, or don't even stop by not doing because you don't think you have the money. And then finally,
could they apply for arbitration with a landlord or no?
well, actually, the lease will sometimes say you must go through arbitration.
Okay.
It just depends on what's in the lease. If arbitration is not in the lease, but for some reason you want to arbitrate, then you could ask them, would they agree to binding arbitration? You're more likely to get mediation, where you and the other side go to a mediator, and of course, nothing is, no, I shouldn't say that. Generally, it's not free. Some things are free, but generally that you're going to pay at least $100 or $200. But you could go through mediation, and mediation is where, let's say Myra is the mediator and I'm the tenant and someone's the landlord, and we go to Myra and say, hey, here are my facts. And the landlord goes, nah, here are my facts. And Myra goes, well, would you be willing to accept this and this so that you all can both move on with your lives, get rid of this stress? Maybe somebody gets a little more money than they thought, or maybe someone keeps a little more money than they were told. And no one has to go to court and there's no public record and we just go on about our lives. That could be an option too.
Right. Well, thank you so much.
Sure.
We really appreciate you and we're very grateful to you, Mark.
Thank you. You're too nice.
This is so informative and I really appreciate you. Thank you so much from the
pleasure.
Month of Service Partners and our collaborators also.
All right.
Thank
You all,
you.
everybody have a great day. Bye.
Thank you. Guys, the Month of Service program tomorrow, this is tomorrow's virtual workshop is going to be on money, health, and wealth, savings, establishing a rainy day fund. Now, guys, we do the Houston Bar Association is one of our partners, and they had Mr. Mark come in and give a class. We do the legal side of it so we can make sure everyone's educated, but we also do the money, health, and wealth side of it, helping you clean your credit up, helping you create savings. Because when you're buying a house, they want to know how much money have you saved and where did you get your money from for your savings and for your deposit. So we're teaching you and trying to help you on getting your credit cleared up, as well as, let's save, let's invest, let's, take care of our financial aspect also. So that's tomorrow from 4 to 6. And then on Thursday, we'll have Lone Star Legal Aid, and they will be talking about wills and advanced legal planning. Now, guys, this is one of my big babies. I think every generation should be able to pass your generational wealth onto the next heirs. The sad part about this process, a lot of people do not create an estate plan. They don't pass their generational wealth, and they don't protect their heirs from the vultures. And the vultures are everyone else that wants your property. So I think one of the most important thing in life, if you drive down 288, if you drive down 610, if you drove down 288, maybe about 20, 30 years ago, the way it looks completely different than what it looks now, which it's great. But a lot of times people, the heirs, lost their generational wealth because most of their parents did not create an estate plan. So then kids were fighting for their parents' estate, or they were not paying their taxes. And there was always, well, I'm not going to pay the taxes if it's not going to be under my name. So guys, one of the most important thing is protecting your generational wealth and passing it on to your heirs. And that's on this Thursday from 1 to 3. And we will see Miss Jessie Campbell from Lone Star Legal Aid educating us all on how to protect our generational wealth. And we can do it ourselves. You don't have to hire an attorney. You can create a transfer on death deed, or you can create your own will, or, talk to an attorney and discuss the process with them. There's different ways of protecting your generational wealth. And that's what the Month of Service is all about. We want to make sure that you know that you're not alone and that we are all here with you. So, a lot of times, hey, we think our kids are never going to fight, and I can promise you one thing, they will argue, even over a piece of earring, just an earring like this, they will argue about. So, your children, as I know mine. So make sure to protect your generational wealth. And we will see you tomorrow, learning how to create your savings, how to clear up your credit. We'll see you on Thursday on how to protect your generational wealth. Thanks, guys. You have a great day. Thank you, Mark. We
You're
really
welcome. Thank you,
appreciate
Myra.
you. And
Happy
guys,
to
go
help.
to nrcdc.org and register. Thanks, everyone. Have a great day.
Take care.